Assalamualaikum warahmatullahi wabarakatuh. Welcome back to our recorded lecture. So for today, we are going to discuss the topic of damages. So basically, this topic is the final topic for this semester and for the syllabus of Law 1211. So finally, we did it. We have come to the end. But for this particular topic, I think we have at least 4 parts of recorded lecture, or maybe 5. It depends. Okay, it depends on how long my explanation for each slide is. Okay, all right. So for our topic is damages. Okay, for breach of contract. Actually, this topic also you learn it under law of torts. Okay, you learn it law of torts 2, law 1511, and you learn it for as the first topic. But for law of contract, law 1211, we learn it, we keep it until the end of the semester, the end of the syllabus. So it's like the ending part of the whole topic for law of contract. Okay, let's have a look at the introduction here. So whenever, usually a contract involves 2 parties, okay, 2 contracting parties. It's a bilateral in nature, okay, and sometimes one of the parties might suffer losses. And because of what? Because the other party has breached the contract. Or another term you can use as has broken the promises, okay, to honor or to keep the promise, okay. So basically, whenever there is any breach, okay, the other party, the victim, he or she will be entitled to an award of damages. He can claim for monetary compensation because of the breach. Because why? After they enter into the contract, by right, okay, legally speaking, they have to keep their promise. They have to perform whatever that they have promised to. But in the event one of them is in breach, then the other party, okay, has the right to sue or to ask for the claim of damages. So what's the basis of allowing the claim here? Okay, what's the aim, okay, of allowing the claim for damages? All right, so basically damages are normally awarded by the court on the basis, on the ground, okay, or with the intention of placing, okay, putting the injured party in the same financial position as if the contract had been properly performed. Whenever the money can make good of it. But if we compare to the basis of damages under law of torts, okay, it has slightly different approach. Okay, for law of torts, okay, damages are awarded as if for example, negligence, okay, as if the tortious action never happened, and try to compensate the party in order to put them in their early as if the torts never happened, as if the parties, the victim is not injured. But for law of contract here, okay, the basis or the ground or the aim here is as far as possible, okay, to place, okay, to put the injured party in the same financial, so that's the word, financial position, as if the contract had been properly performed. For example, the party, okay, the promisor promise, okay, to deliver the things, but then there was a breach, non-delivery, so we try to award damages to the other party as if the things, okay, the subject matter has been properly delivered. So that's the example. Okay, for damages, we have one important section. Okay, so our discussion revolves around this section, which is section 74. Okay, so I believe you have Contracts Act with you. I don't reproduce the whole provision. I just put the essence or the important part of it. If you refer to your section 74, you have subsection 1, 2, and 3. Okay. All right, but for the first part of discussion, we're going to focus on subsection 1, okay, 74 subsection 1. It talk about compensation for loss or damage caused by breach of contract. So the word used is compensation. So it denotes damages, basically. So if you read the full, let me read to you the full provision here. When a contract has been broken, so that's the word broken, the party who suffers by the breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby. And then that's the one that I reproduced, okay, which naturally arose in the usual course of things from the breach. And you have the word or which the parties knew when they made the contract to be likely to result from the breach of it. So basically, this is the we divide the provision, okay, into two parts or two limb, we call it, okay. And this limb actually it illustrate, okay, it explain in what position, in what situation damages or compensation can be allowed to the victim, to the party who suffers injury or losses here, losses, financial injury or losses. All right. So there are two limbs under Section 74. The first one, okay, from the word which naturally arose. Take note, they use the term, the past tense. Okay, the tense is in something which happened in the past, already happened, which naturally arose in the usual course of things from the breach. Or, okay, the second limb, meaning here either one. You prove, I mean, the party has to prove either one. Another one, which the parties knew. Okay, knew, that's the word, the keyword, when they made the contract to be likely to result from the breach of it. So there are two limbs of which the parties, I mean the party, the party who suffers losses, they can claim for compensation. And actually, in essence, okay, the rule in Section 74, it originates from the rule in the landmark case, common law landmark case, Hadley and Bazendale, 1854. And this is actually the leading case on damages, the leading case on remoteness of damage as well in contract. So that's the quotation from the judgment of the case. The damages should be, as may be fairly and reasonably be considered, either arising naturally. That's why the words can we adopt into our Section 74. According to the usual course of things, from such breach of contract itself, or such as may reasonably be supposed to have been in the contemplation of both parties at the time they made the contract as the probable result of the breach. So basically, this part of the judgment from Hadley Bazendale, okay, it was, it is adopted into our Section 74 Contracts Act 1950. Okay, let's go to the facts of the case. The case is quite simple, but then the rule or the ratio is very, very important. So what happened? The plaintiff is actually a mill owner and they own certain crankshaft in order to run or to operate their mill. So the plaintiff crankshaft broke, okay, and then it was the only one they had. Okay, they only have one crankshaft, okay, because maybe some other bigger mills they have more than one. And without the crankshaft here, they could not run their mill. So they have to send it for repair. So they contracted with the defendant to send it to the engineers. So defendant is responsible for fixing or for the repairing. And what happened was that there was delivery. So the delivery was delayed, and because of that, plaintiff suffered damages because they could not run their mill, could not open, could not do their business. Okay. So now the plaintiff sued for lost profit, whatever profit they lost. So they are now putting the blame. They are suing the defendant, because defendant is the one who was responsible for the delay. So now the issue was that, can the plaintiff recover the lost profit? So the decision was that the answer was no. Why is that so? Why the plaintiff cannot claim against the defendant? So this is just for your information. This is how it looks like, okay, the crankshaft. So plaintiff only have one of it. So without this, they cannot run their business. So this is the rule. Okay, this is the rule that which is extracted from the Hadley Bazendale just now. The court found that an aggrieved buyer of services, okay, will be unable to recover consequential losses resulting from breach unless the losses are, so this is the way, in order to be able, for the party to be able to recover, aggrieved buyer, the aggrieved party. First, a natural consequence of breach, or the buyer, in the case Hadley, okay, the buyer brings the circumstances which would generate the losses expressly to the seller's attention, must inform, must disclose all the relevant information to the other party, to the seller. Okay, and the court give reasoning why the court did not allow the claim, okay, by Hadley against Bazendale. So the court reasoned that defendants had no way of knowing that plaintiff would lose profit if the shipment of the shaft was delayed. No knowledge at all, okay, on the part of the defendant. As this information wasn't communicated directly to them, and therefore the loss of profit was not reasonably contemplated. Not in their contemplation, they have no idea, no reason to know, okay, by both the parties when they made the contract. And then, although the fact that the mill was closed, the mill was closed was communicated, but then it wasn't made completely clear to the defendant that the mill was closed because of the broken shaft and couldn't reopen again until it was fixed. So basically, defendant knows, okay, the mill was closed, but they never know that the plaintiff only had one and only one shaft. That's the reason why the mill was closed. So because of the missing of certain facts here, it wasn't made completely clear to the other party. So later, whatever problem, plaintiff cannot claim against the defendant for the delay. So this is the analysis from the case because the case is landmark, so very important. So basically from the case, we learned that indirect or consequential damages are only recoverable, yes, if reasonably foreseeable by both of the parties at the time of the contract and it arises naturally from such breach. So, and then the if situation, okay, if the plaintiff, Hadley, had made it clear that the mill's operation was dependent upon getting the new crankshaft, then the outcome would have been in their favor. If they have made it clear to the defendant, okay, so that they can claim for whatever lost profit. But in this case, what happened was that they never made it clear. They told the other party they closed the mill, but they never told what's the reason of doing so. So defendant didn't know, okay, whether the delay will affect their business or not here. Maybe because they thought plaintiff maybe have some other reason, okay, for closing the mill. Okay, the next case for us to be discussed, also another leading case, the principle laid down in Hadley Bazendale was restated, reaffirmed, restated, okay, reiterated by Court of Appeal in this case. Victoria Laundry Windsor Limited and Newman Industries Limited, 1949. So it just now it was about crankshaft, okay, late delivery for when it was sent for the fixing. Now it's about late delivery of a boiler to Dyers. So Dyers, it refers to person, okay, it refers to the one who is responsible for the business in doing dye. I mean, it's like coloring, is it? So the Dyers claim, okay, two things here. First, they are because of the late delivery, okay. First, loss of profit arising in the ordinary course of business because they are in laundry business, so they need the boiler. And another one, the second claim is loss of exceptional profit on especially advantageous government contracts. So they are anticipating a contract, a very lucrative contract. But then because of the late delivery, they could not secure the contract. So now they're claiming whatever their losses, okay, against the one who is responsible for the late delivery of their boiler. So now the issue is, what can we allow both of the claim? Okay, here, what part of the plaintiff profit can they recover? Because they suffer two categories of profit here. First, loss of profit because cannot do business. Another one, loss of exceptional profit that they should have been made. They should have been making if they managed to secure the government contract. So basically, they lose the contract. They lost the contract. So this is the picture of boiler, okay, like that. So it's a very big big plant or machinery here, okay, in order to do the laundry business. Okay, now we go to the rule from Victoria Laundry just now. So when there is a breach of contract, the breaching party, the contract breaker, should be liable for damages that naturally arise from the breach or damages that both of the parties, both plaintiff defendant, contemplated at the time they made the contract. So in Victoria Laundry, the ordinary loss of profit fell within the first head, first limb, which is recoverable. So late delivery of boiler, it will affect the laundry business. So something which is naturally, okay, which is natural. So the loss is something which naturally arose from the breach, from the late delivery. But for the second claim, the exceptional profit on government contract, it fell within the second head, second limb, and it wasn't recoverable. Okay, were not allowed to be recovered. Why? Because the defendant had no knowledge, okay, that the boiler was required to fulfill this contract, unusually profitable contract. If we put if situation, let's say they have informed from the very beginning, okay, I need the boiler, I need to secure contract with government, for example, yes, they can claim. But here in this case, they didn't inform, they didn't disclose. Okay, but the first one, something which is natural, late delivery of boiler affect laundry business. But second one, cannot secure government contract, but never inform, okay, from the very beginning, so cannot get compensation. Okay, so the case analysis again, the court says it is reasonable to think that since the defendant knew, okay, The plaintiff was in the laundry business, so yes, this is something which is foreseeable. It was foreseeable that the lack of a boiler would keep them from receiving the profit laundry people usually get. And the engineering company cannot plead ignorance as to what the boiler was for. So this is on the part of the defendant, because why? Any reasonable person would understand that it is essential to their business. So without the boiler cannot do the business. And then we have the third case, also discussing and applying the same principle. The above case was discussed by House of Lords in, yes, not by Court of Appeal, now House of Lords in the Heron 2, 1967. I think Heron here is the name of the ship, if I'm not mistaken. So now it's about business of delivering sugar, okay? So the plaintiff contracted with the defendant, so plaintiff is the buyer of the sugar, to deliver sugar to Basra. And that's the name of the place. Okay, defendant was late delivery of sugar, and in the meantime, another vessel with sugar arrived in Basra. So it caused the market price to drop. So the plaintiff now sued for the difference between the amount that it would have been received if the contract had been performed. Okay, if the sugar arrived on time, so he should have secured this amount of profit. And actually he got lesser profit because of the late arrival of the sugar. Okay, and the amount the plaintiff actually got. So there's a gap here. For example, he's expecting to get 100 million, but he only get 90 million. So the gap, the loss of profit is 10 million. That's example only. Okay, now what's the issue in this case? The Heron 2, shall the plaintiff receive the requested damages? So what's the rule in order to resolve the issue? The rule is that if the loss is foreseeable, that's the word foreseeable, then it may be compensated. And then House of Lords also discussed about how serious the risk of loss must appear at the time of contract in order to be considered foreseeable. Is it something which is very, very serious? How serious the risk is? Okay? And then the court came to the conclusion, the ship owner must be presumed to know that prices in commodity market fluctuate. It goes up and down easily, quickly. Okay? And delay, whatever delay 1 day, delay a few hours also, it affects the whole thing. In the usual course of thing, will cause certain loss as a natural and probable result of the breach. So because of that, the appellant was liable under the first limb, something which is natural. Okay, late delivery of something in commodity market, because the price fluctuates, then yes, the other party suffer damages, so can claim, suffer damage, so can claim damages from the other party. Okay, all right. We are done for the first three cases, in which actually we adopt the rule from common law, but basically our section 74 is essentially based on Hadley-Bazendale, and Hadley-Bazendale was applied in Victoria Laundry and later was reaffirmed in House of Lords case of the Heron 2. So we stop here. Okay, later we are going to discuss thoroughly about first limb and second limb of section 74 together with the case law, local cases, of the application of the rule. Okay, I stop share first. Okay, thanks for listening. I'll see you in the part 2 of the same topic. Okay, the continuation of the part 1. Assalamualaikum warahmatullahi wabarakatuh.